committee to order this morning. You might notice that most of the lights are not turned on, and in fact, I think none of the lights are turned on, and that is in an effort to conserve some energy due to the blackouts that are happening across Kansas. So we hope everyone is staying safe and warm as we go through this cold spell. Yes, Senator Thompson.
Madam Chair, just a quick note. I did talk just now to Mike Ross of the Southwest Power Pool, and they're working very hard to get this situation resolved. He did tell me he thinks that they should have it fixed by noon. Part of the problem is there's such a high electrical demand. But anybody listening in, I thought they might appreciate the fact that they're working as hard as they can to alleviate the necessity for these rolling blackouts across the Southwest Power Pool. So that's the very latest.
Thank you for that update, Senator, and we are glad for the hard work that those working at the Southwest Power Pool are engaged in. The Southwest Power Pool is a conglomeration, if you will, of 17 states, all the way down from Louisiana up to the Canadian border that share and pool energy resources. So they're working diligently as they can, it sounds like. So thank you for the update. And it looks like warmer weather is coming, so we appreciate that as well. It's a sunny day, and that's certainly welcome. And want to take just a moment. We had another member celebrate a birthday, another committee member, that would be Senator Bowers last week. So happy belated birthday to you. And hope it wasn't too cold out there for you on that one. So, well, good. Good. Well, and thank you all for joining us today. With that, then, we will turn to committee business, and we will open the hearing on Senate Bill 150. And we will first then ask our reviser, Mr. Thompson, for a bill brief.
Thank you, Madam Chair, and good morning, committee. Senate Bill 150 defines and prohibits certain deceptive lawsuit advertising practices and restricts the use or disclosure of protected health information to solicit individuals for legal services. Section 1 requires a person engaging in legal advertisement within the state to follow certain rules, including disclosing that the advertisement is for legal services and also disclosing the sponsor of the ad, and it also prohibits the use of certain words and logos. Legal advertisement is a defined term that means a solicitation for legal services through television, radio, internet, including a domain name, newspaper or other periodical, outdoor display, or any other written, electronic, or recorded communication. A violation of Section 1 is an unlawful and deceptive trade practice as provided in our Kansas Consumer Protection Act and would be subject to the civil penalties provided in that act. Section 2 then provides that a person shall not use, cause to be used, obtain, sell, transfer, or disclose to another person without written authorization protected health information for the purpose of soliciting an individual for legal services. Protected health information, of course, is a defined term, and it means the same as in the HIPAA privacy rule. That's the rule provided in the subtitle of the Health Insurance Portability and Accountability Act of 1996. Finally, a violation of Section 2 would also be an unlawful and deceptive trade practice as provided in our Consumer Protection Act and would be subject to those same civil penalties. Finally, a knowing violation of the section would be a Class A non-person misdemeanor. So on top of the civil penalties, there's a criminal penalty. With that, I'll stand for questions.
Thank you, Mr. Thompson. Committee, are there any questions? I do have one question. Do we know whether other states have enacted something similar? Or is that a better question for a conferee?
Thank you, Madam Chair. I am Jason Thompson again. I am not aware of the other states. This bill's been introduced before, but I don't think has had a hearing, so we haven't received that testimony. And if the conferees aren't able to help, I'm sure between us and legislative research, we can get you that answer.
Right, certainly. And do we have Ms. Natalie Nelson with Kansas Legislative Research Department on the call with us?
Yes, I am here. I am not familiar with this either, but I can look into it.
Okay, great. Thanks.
The conferees don't know.
Exactly. All right, great. Well, with that then, we will invite, if there are no other questions for the revisor, and seeing none, we will then invite the first proponent conferee, Mr. Eric Stafford, with the Kansas Chamber of Commerce. Please introduce yourself and welcome again to committee.
Thank you, Madam Chair and committee members. Good morning. My name is Eric Stafford with the Kansas Chamber of Commerce, here to speak in support of Senate Bill 150. Appreciate the opportunity for the hearing today on this bill that deals with deceptive advertising practices for legal advertisements. To answer your question, Madam Chair, I believe on the footnote of Mr. Silverman's testimony, he lists, I think it's Texas, Tennessee, and West Virginia are the states that have passed similar legislation to this subject. And again, I think that's cited on his written statements provided to you. So we do appreciate the opportunity to be here in support of Senate Bill 150 today. And this bill prohibits specific deceptive advertising practices. We've all seen the late night advertisements that, you know, have you taken Pradaxa or any sort of medication or used a certain medical device or talcum powder as another example. And the purpose of these advertisements are all to generate leads for what is the U.S. Chamber puts in their words in a white paper that they've put together as a cycle of lead generation, which leads to litigation, which leads to multi-million-dollar settlements. So the return on investment, in their view, to spend a few $100 million on advertisements to generate potential leads is pretty rewarding for them because oftentimes they're not, there's not an actual recall, no harm to the patients outside of the normal level of risk of any certain medication. I think Pradaxa is one in a white paper I reference in our testimony that talks about that the Food and Drug Administration said that they were investigating an increased risk of bleeding, but it turns out that there was no higher risk than any other drug that had been on the market, but it still resulted in a multi-million-dollar settlement. Pretty straightforward bill. Section 1 establishes guidelines for advertising. You can't present this as a medical alert or health alert or other similar terms. The bill prohibits the use of any federal or state agency logo to insinuate or imply some sort of government-sponsored message of concern here for consumers. The word recall cannot be used if there is actually not a recall. Pretty simple requirement there. And a statement that if alleging an injury from a prescription drug approved by the FDA, that there must be a warning urging viewers not to stop taking their medication without first consulting with their doctor. When we were first told about this issue, there was testimony provided, I believe, in Texas. There was a patient who quit taking their medication because they saw one of these advertisements without consulting with their physician and ultimately ended up having to have both of their legs amputated. So again, wanting to ensure that these efforts to solicit leads do not result in any misleading information on what the actual risk might be. Section 2 addresses a practice where data is being collected for this lead generation. So it appears that you're calling a law firm. It appears that you're calling attorneys who can help you with concerns over a prescription or medical device. But it turns out it's just a data collection agency who's taking your information and selling it to law firms to use for potential lead generation. So that just requires written consent, written authorization for the sale, transfer, or disclosure of protected health information for the purpose of soliciting legal services, and failure to collect that subjects these provisions to the Kansas Consumer Protection Act. Before I close, I'll let Mr. Silverman say more comments about the bill, why we're pursuing it, and but before I close, I'd like to say that we're working on the definition of legal advertisement and solicitation. We were approached by the Kansas Justice Institute, who had concerns over that, and so we're trying to come up with some language to address their concerns to the bill. They're in support of the concept, but they're worried about the implication on their organization. So we're trying to figure out how to navigate through that. So if this bill's ultimately worked and moving forward, just know we're not quite there yet, but still trying to finalize some language on that. So with that, be happy to answer any questions at the appropriate time, Madam Chair, and thank you for the opportunity to be here today.
Thank you, Mr. Stafford. Appreciate that. And committee will go ahead and take questions of all the proponent conferees once we've heard from all of them. So thank you. And next, then, we will hear from Mr. Kerry Silverman, U.S. Chambers Institute for Legal Reforms. And I believe Mr. Silverman is on WebEx. So please introduce yourself and welcome to committee.
Here we go. Thank you, Madam Chairwoman. Can you hear me okay?
Yes, I can. Please make sure you speak directly into your microphone, but we can hear you. Thank you.
Okay. Thank you. Madam Chairwoman and members of the committee, thank you for the opportunity to speak with you today in support of SB 150 on behalf of the U.S. Chamber of Commerce's Institute for Legal Reform. I'm an attorney at Shook, Hardy, and Bacon, where I've practiced for 20 years, and I have closely studied and written about lawsuit advertising practices. By now, you've likely experienced the constant daytime and late night advertisements for legal services. If you've watched them as closely as I have, you'll notice that they follow a very familiar script when they are targeting medications or medical devices or consumer products. They begin with some scary music and a dramatic voiceover and some official sounding language that gets your attention, like medical alert or drug alert. Some of them are framed as public service announcements or news reports, suggesting that the ad will provide impartial health information. And some might just be called the helpline. And after they get the viewer's attention, they list a range of illnesses or medical conditions, attributing them to the product. Those risks may be contrary to science. They may be risks that are extraordinarily low, or they may be risks that are fully known and understood by regulators like the FDA or by doctors and their patients. Sometimes during the commercial, the official logo of the FDA will flash in the background, giving it an official look, as the announcer tells the viewers that the safety of the product is being investigated, that some study has found the product may cause an illness, or that the lawsuits against the manufacturer have resulted in multi-million-dollar verdicts, some of which may have been thrown out or reversed on appeal. Ads commonly conclude by telling viewers that if you or a loved one use the product, call right now because you may be entitled to substantial compensation. And then the final screen of the ad flashes, telling viewers that showing viewers an illegible fine print, some of which may be spoken and hard to read. And in that fine print may be the identity of the law firm or the entity sponsoring the ad buried in it. Similar tactics are used online, where websites such as medrecallnews.com feature photos of doctors and suggest that they're there to provide unbiased information on recalled or dangerous products when they are disguised lawsuit referral services. And as Mr. Stafford said, the goal of these ads is to generate as many leads as possible to fuel malice toward litigation, and ultimately to pressure business to settle cases regardless of a scientific consensus that the product may be safe and beneficial. The problem, aside from it from a civil justice perspective, is the implications it has for public health when these types of ads and these practices are unconstrained. There is mounting evidence that these misleading types of tactics targeted by the bill and the exaggerated claims made in these ads lead people to stop taking their prescribed medication without talking with their doctors first. A 2017 survey of patients who took one or more of 12 medications to treat conditions ranging from diabetes to depression found that 1 in 4 respondents who had taken a prescribed drug reported that they would immediately stop taking the medication after they saw the ad. An earlier survey of psychiatrists who treated patients for schizophrenia and bipolar disorder returned similar results from doctors. These concerns are not hypothetical. They're not just based on surveys. Plaintiffs' lawyers and lead generators spent, for example, over $100 million on ads targeting the blood thinner Xarelto, similar to Pradaxa mentioned earlier. Those commercials, like the usual script, started with Xarelto alert, Xarelto warning, medical alert, or this is an important medical announcement. They then told viewers that Xarelto had been linked to uncontrolled bleeding and death, that it caused stroke, that it caused bleeding of the brain. And some of the ads displayed multi-million-dollar settlements involving Pradaxa, a different blood thinner, while others flashed an early Xarelto verdict that was almost immediately thrown out as contrary to the evidence. In some, these misleading commercials repeatedly told patients that the drug prescribed by their doctors to prevent a stroke could actually kill them. And those misleading ads had real consequences. In 2019, the FDA researchers there searched their adverse event reporting system, which doctors primarily use to identify adverse events in their patients. And they found 66 reports of patients who discontinued a blood thinning medication after viewing a lawsuit ad. Half of them experienced a stroke, 7 people died, 24 people experienced other serious injuries. Most of the victims were senior citizens. And these figures likely significantly understate the number of injuries. Why? Because few doctors or patients or their families may think to report an attorney ad to, of all places, the FDA, or even be aware that the ad sparked a patient's decision to stop taking the drug. 5 years ago, the American Medical Association recognized the danger of these misleading ads, and it passed a resolution calling upon legislators to require at minimum attorney commercials to warn patients not to discontinue a drug before speaking with their doctor. And since then, the AMA has found that these types of misleading practices have become, quote, even more pervasive, and renewed its call for action. And that's what the proposed legislation does. And Mr. Stafford described it for you. It basically targets the very practices that we've talked about today. It requires 3 very simple disclosures: that it's an ad, the identity of the law firm, and if it's soliciting targets for lawsuits targeting FDA-approved prescription drugs, that it contained that warning that the AMA itself has urged, that patients first speak with their doctor before stopping taking their medication. And then it prohibits 3 of the most common deceptive lawsuit advertising practices. Those practices being, starting these ads by calling them medical alerts or public service announcements, flashing logos of government agencies. These are the types, and making sure that we're not using the word recall for products when a product has not, in fact, been recalled. Attorney advertising is commercial speech. It is protected by the First Amendment. It can serve a valuable purpose in linking people who are injured as a result of wrongful conduct with a lawyer, but legislators can and they should step in when lawsuit advertising misleads the public or jeopardizes public health. The U.S. Supreme Court has said that is perfectly acceptable, and those cases are cited in my written testimony. So I thank you, and I welcome your questions, and we express our support for SB 150.
Mr. Silverman, are there any other proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, then I will direct the committee's attention to proponent written testimony from Rochelle Colombo, Kansas Medical Society, and Dan Murray, National Federation of Independent Businesses. And with that committee, then, we will open it up for questions. Senator Corson.
Thank you so much, Madam Chair. I have some questions for the proponents. My first being, what evidence do you have that there's a problem in Kansas with attorney advertising? I know this is not really a Kansas bill. What evidence do you have that this is a Kansas problem?
Do we have a conferee available who can answer the question? Mr. Stafford, please introduce yourself and welcome again.
Thank you, Madam Chair, and Eric Stafford with the Kansas Chamber. Senator, thank you for your question. I don't have specific evidence right now that this is a Kansas problem, but oftentimes legislation is brought forward because of problems that we know that exist, and we don't need to wait for a problem to happen before asking to get something passed. We don't want to wait for something to happen. So I think that while that's a fair point, Oftentimes, we're passing legislation in anticipation of things or because we're seeing trends in other areas that we don't want to have happen in our state.
Thank you. I appreciate that. Mr. Stafford, I know you're not an attorney, and Mr. Silverman, I know you're an out-of-state attorney and that you're not licensed to practice in Kansas. But are either of you familiar with Kansas Rules of Professional Conduct 7.1, 7.2, and 7.3?
I assume that those are set by the Supreme Court just as they are in other states in terms of the ethical conduct of attorneys, is probably what you're referencing. Doing my attorney work through Google over the weekend and last week looking into this issue, I know that that's how states often address this, but anticipating that question, I think the response from me, and I'll let Mr. Silverman add something if he has any comments after, but, our government, state and federal.
Can you explain to the committee what those rules are?
No, I'll let
I don't
you
know
do
if the
it.
committee is familiar with what
You
those
can
rules
out-attorney me. What I was going to say was that state and federal agencies regulate advertisements in the state, and asking for guidelines for legal advertisements to follow within the state is not an unreasonable request, just like we regulate various other industries. So with that said, Senator, if you want to educate me on what those specific rules say, then I'm more than happy to listen and take notes.
Well, I appreciate that. You mentioned that this bill has been enacted in Texas, Tennessee, and West Virginia has passed similar legislation. Can you walk us through, or maybe Mr. Silverman, what the current status of the legislation is in West Virginia?
Mr. Silverman, are you available for a
Yes,
reply?
Senator Corson. Well, first, if I may I backtrack to your earlier question?
Yes, sir.
Regarding 7.1, I didn't have an opportunity. Yes, I'm familiar with that rule, with those rules. They're in place in most states, and generally what they do is they prevent or they preclude attorney advertising that is false or misleading, and the ones that follow Rule 7.1 address some very specific types of practices, such as putting yourself out as an expert in a particular area of law. The reason why Rule 7.1 in particular doesn't quite do enough to address the problem here is that Rule 7.1 is talking about false and misleading communication about, and I'll quote, the lawyer or the lawyer's services. When you get into these types of advertisements, most of what we're talking about here is not about the lawyer's services. It's not about their fees. It's not about how they're going to represent the clients. It's not about what's in their contract. It's not about how a contingency fee works. It's about the public health implications, the statements that are made in there that are misleading with respect to the drug, to the health impact, to whether this is a health service. They go beyond the lawyer's services and what's typically viewed by bar associations as falling in within the rule. And the other issue with relying on bar rules is, unfortunately, the way that most bars, and I won't pretend to be an expert on how Kansas works, but what I've seen in most states is that bar enforcement is typically reactive. It happens when a client feels wronged by a lawyer, where they feel they've been ripped off or not treated fairly, or their calls were not returned. And so they'll file a complaint, and the bar will then take action on that complaint. But when we're talking about these types of ads, the people that are harmed aren't clients of the lawyer. They're the people who are watching the ads. And folks aren't going to their families, or people who are patients in hospitals. They're not going to think, I'm going to file a complaint with the bar association when someone stops taking their medication. If anything, they'll go to the FDA, but the bar association isn't the place where they'll typically turn for that.
And did you want to answer my question about the status of this legislation in West Virginia?
I'm looking for that. I believed it had been enacted. I have it cited in my testimony, in my written testimony.
I can help you with the answer if you need it.
Okay, please do.
So the legislation has been enjoined by a U.S. District Court in West Virginia. Do you know why it's been enjoined?
I don't.
It's been enjoined because it violates the First Amendment of the United States Constitution.
Is there a question for the conferee, Senator?
Well, I'm just surprised that the conferees would, my question is, do you typically push for the enactment of constitutionally suspect legislation?
Let's stick to the topic here if we could, Senator.
Well, this is constitutionally suspect legislation. I'm just wondering if that's a typical practice.
I understand that's your opinion, Senator.
It's not my opinion. It's the opinion of the United States District Court in West Virginia.
Well, I'm not going to argue with you, Senator, but if you have a direct question, that's...
Well, I do have a direct question. So it seems like
Let's not cut me off, please.
Point of order.
I wasn't finished speaking.
Oh, sorry, Madam Chair.
Point of order.
Wilborn.
Let me remind the good senator from Johnson County that this is not a courtroom cross-examination. Address the chair, please.
Thank you, Madam Chair. Could I follow it up with a more direct question?
If it's appropriate, I'll listen to the question.
Okay. My question is, in looking at the fiscal note, the Office of the Attorney General states an enactment of this bill could be constitutionally challenged by individual lawyers, law firms, or legal organizations. The defense could be handled by the agency. However, it is possible that outside counsel would be needed to defend any lawsuit. So my question for the proponents would just be, how long will this litigation last? How much will it cost Kansas taxpayers? And what do we think our likelihood of success will be if we enact this litigation or this legislation? Thank you, Madam Chair.
Thank you. If the conferees are able to answer as best they can, please go ahead.
Gary, I'll defer to you real quick as I look something up. If you have any comments on the Attorney General's, Madam Chair, if that's okay.
Sure, for
I
either.
didn't know we had a fiscal note, so that's news to me.
Let's see here. We do have a fiscal note. There's no dollar amount associated with it, but there is the comment that the Office of the Attorney General states enactment could be constitutionally challenged by individual lawyers, law firms, or legal organizations. And
Madam
defense
Chair.
could be handled by the agency. However, it's possible outside counsel would be needed. If that helps in your reply.
Madam Chair, may I respond?
Yes, go ahead, Mr. Silverman.
I mean, it doesn't surprise me that some plaintiffs' lawyers will challenge any sort of restriction on attorney advertising. That's to be expected. But the U.S. Supreme Court has ruled in several instances, some of which are discussed in my testimony, that it is perfectly constitutional for the legislature to play, or state bar associations, to place restrictions on misleading attorney advertising practices. This bill is very specific in doing that, and looking at these very types of practices that the FTC in other contexts, and actually in this context, has found to be deceptive. So it should withstand review. Now, it is news to me that there was an injunction imposed in a law in West Virginia that was just recently enacted. Typically, an injunction is a preliminary ruling, doesn't go to the merits. And so I would want to look at that more closely and see where that goes. But this is a district court level injunction, at least that's what's been presented here. It hasn't gone to a full ruling. It hasn't gone to appeal, and hopefully it won't, because these types of laws have been upheld by the courts.
Thank you. Any other questions? Yes, Senator Thompson.
Thank you, Madam Chair. Question for either Eric or Mr. Silverman. With regard to broadcast entities who broadcast these advertisements, particularly along state lines, I'm thinking about Kansas City, where the broadcast towers on the Missouri side, but they broadcast a fairly significant pattern into Kansas. How would that impact? obviously Kansas consumers see these advertisements. How would that impact that cross-state line broadcast type situation?
Thank you, Senator. If Mr. Silverman or Mr. Stafford could answer.
You want to take a crack, Carrie?
Sure. Well, those ads, like any other, deceptive advertisement falling under the unfair practices law, the consumer protection law, would result in the potential, if it impacts someone living in Kansas, then there would be a potential claim to stop that type of deceptive advertisement.
Okay. So in other words, we could stop that advertisement even though it was emanating from Missouri into Kansas or Oklahoma into Kansas, for example.
Yes, I believe so.
Okay. Thank you. Thank you, Madam Chair.
Committee, other questions? I have a quick question. I see in the bill on page 2 at section section 2, subsection B2, that I'm familiar with the Kansas Consumer Protection Act, and that this would then fall under the Kansas Consumer Protection Act as another deceptive trade practice as defined in the statute. What I think is new to the Kansas Consumer Protection Act, and if you could speak to it just briefly, would be in addition to the remedies, the civil remedies that the Kansas Consumer Protection Act provides, such as fines and injunctions and things like that, would be a criminal remedy, that it would be a class, if you're found guilty of violating this statute, you could be guilty of a Class A non-person misdemeanor. And I'm wondering if either Mr. Stafford or Mr. Silverman could speak to that a little bit, because we don't have any, as I recall, any criminal penalties for violation of the Kansas Consumer Protection Act.
I would, Madam Chair, defer to Carrie on that provision, but I would say that if that's problematic, we could look to take that out, if that's differing than how we've typically handled those claims before.
Understood. Mr. Silverman, is that your position as well?
Yes, I'm not familiar with that provision in Kansas law on that aspect.
Very good. Are there other questions for our proponent conferees? Seeing none, then, we will turn to any neutral conferees. Are there any neutral conferees in the committee meeting room or on WebEx? Seeing and hearing none, then, we will hear from our opponent conferees. We will first hear from Joe Molina, Kansas Bar Association. Please introduce yourself and welcome to committee.
Madam Chair, Joe Molina with the Kansas Bar Association. I appreciate the opportunity to speak to you guys today. I haven't seen you in a bit. And so this is refreshing to be in person. I was going to testify via WebEx today, but I didn't trust a power outage. So I get to see all you fine people today. I'm here today with the Kansas Bar Association because we oppose Senate Bill 150. Our opposition is based in the Kansas Constitution. Article 3, Section 1 clearly states that the Supreme Court has the general administrative authority of all courts in the state of Kansas. That has come to include lawyer discipline. That also includes how lawyers become lawyers in the state of Kansas. Attorney admission, that includes how many continued legal education hours lawyers need to take. That also includes what type of conduct is to be misleading or could be found to be misleading or deceptive. We had a lot of talk about Rule 7.1, 7.2, 7.3. I've listed those in my testimony. Those are rules of professional conduct. Those are rules put in place by the Supreme Court to deal with these types of situations that we see in Senate Bill 150. We have a structure The way it works now is the Supreme Court sets these rules. We have a specific office, the Office of Disciplinary Administrator, Stan Haslett, a couple blocks from here, actually, who will actually receive complaints. They will investigate complaints, they will hold hearings, and then they'll make a recommendation to the Supreme Court on the type of discipline, if any, right, a certain case or complaint leads to. The Supreme Court then will go ahead and make a final determination on what that punishment could be. And it can be severe, and it has been severe. Right? You can get suspended from the practice of law for doing certain things. You can get disbarred. And Kansas is one of the most difficult states in the nation to get reinstated once you're disbarred. I've only heard of 2 or 3 times where someone has been disbarred and the court let them back in. So these are very serious penalties to any lawyer. We take them very seriously. The bar takes them very seriously. And that is the crux of our opposition to this bill, because we have a process to deal with these types of misleading and deceptive actions. I'd also like to point out that when you talk about First Amendment types of issues, laws can and have been upheld, right? But you must meet a very strict test. There's 2 tests that could actually be applicable in this situation. We've talked about one of them here before when we had the value them both amendment hearings. One of them's a compelling state interest. That is the highest of highest bars. That is strict scrutiny. That is a very difficult bar to get over. There's also another test called the intermediary test. Again, you need to have a very significant state interest, but you also need to be very, very sure that the way you prohibit the speech is the least restrictive manner possible. And in the bill, you will find a section where they state that nothing in Senate Bill 150 will affect the Supreme Court's authority over general government functions of the courts. That in and of itself is an acknowledgement that there is a less restrictive way to go about prohibiting misleading and deceptive acts. And that alone, right, will make it very difficult for this bill to stand up to constitutional scrutiny. We've seen this in a bill out of West Virginia I found over the weekend. It's again, a district court out of the 4th Circuit. We're in the 10th Circuit, so it is not binding. It is persuasive, but it is very persuasive because its underpinnings are based in Supreme Court cases of the past, basically from 1976 and 1977. Those actually provide protection to legal advertising. They create a particular class called commercial speech, which this falls under. And then you would need to go ahead and find something that is of the state interest and is the least restrictive method to do what Senate bill tries to do. And the least restrictive measure here is to fall back on the constitutional authority given to the Supreme Court and allow them to handle misleading and deceptive advertisements. And that's the position of the Kansas Bar Association. I'll stand for questions when appropriate.
Thank you, Mr. Molina. We'll go ahead and hear from all the opponent conferees, and then we'll open it up for questions from the committee members. Next, then, we will invite to hear from Jason Roth, the Kansas Trial Lawyers Association, who's appearing on WebEx. At the start of committee, however, got a phone call that there's a blackout where Mr. Roth is, and he hopes the power will be restored soon. So I will pause and ask if he's online and available now to testify. If so, please introduce yourself and welcome to committee. We've checked with our IT personnel here in the committee room, and we're not seeing that Mr. Jason Roth is on WebEx. So we will go ahead with the other conferees and circle back one last time before we close the hearing. So with that then, I would invite Cody Clausen from Devon James Law Firm, who's appearing on WebEx. Please introduce yourself and welcome to committee.
Good morning. Thank you, Madam Chair. Thank you, committee members. My name is Cody Clausen, and I'm from Newton, Kansas. I work in Wichita, Kansas. It's an honor and a privilege to be here. This is my first time testifying before all of you, and I very, very much appreciate the honor to be here. I was a page in that Capitol building 3 times when I was a young man. So I appreciate all that you all do for the state of Kansas. I am here on behalf of Devon James, but more importantly, I'm here on behalf of myself individually. My family's from Harvey and McPherson County, And before we talk about the merits, or the lack of the merits rather in this bill, I want you all to hear me say, our firm does not engage in these types of ads at all. We never have, we don't intend to, we don't handle pharmaceutical type cases. I'm not here in any capacity other than I have a problem fundamentally with this bill. It doesn't affect our business, so I'm not here in that context. You might be asking yourself, well, then why am I here? Well, because bad law is bad law. And one of the things I was taught by both sets of my grandparents was our Bill of Rights are important, and that's why this bill is important to me. I don't want to go over all the exact same points that Mr. Molina made. He hit the big talking points. I want to just add a few more talking points to those points he made. I learned a lot from my grandparents, and one of the concepts that my grandparents taught me and my dad has taught me, and I'm teaching my children, is I want the government involved in my life as little as possible. And I think everyone can generally agree with that. And when we have another layer of government overseeing what our businesses are doing in this state, that's not a good situation. As Mr. Molina has pointed out, attorney advertising is already very well regulated in this state. There's 8 attorneys in the Kansas Disciplinary Administrator's Office who their sole job is to make sure no attorneys are violating Rules 7.1, 7.2, or 7.3. That's their job. That's what they're paid to do, and they do it very, very well. The reality is Stan Hazlitt is on this issue, and if we had another layer of government control, that's not what Kansas is about. Specifically, the Supreme Court actually regulates attorney advertising. Stan Hazlitt's office through the Kansas Disciplinary Administrator's Office just helps them with that task. I want to talk a little bit about the First Amendment issue in this case. It is a big issue in this case. I think everyone agrees that there's certainly no doubt that if enacted, this law would be challenged in the state of Kansas. The bill in West Virginia that was passed is identical to this bill. This is a bill that was set forth and it's churned out across states throughout the state or throughout the country. It's identical in verbiage. It's struck down as unconstitutional. Mr. Silverman is correct. It is a preliminary injunction. What he left out was, as a general rule, when a preliminary injunction is granted like that, that generally goes to the merits of the case. The other issue I want to talk about is with respect to Mr. Silverman discussed a little bit about how this is for patient safety, and I'm all for patient safety. The only thing our firm does is handle cases where people are injured and need our help. There was talk about how much money is spent in attorney advertising. What they didn't tell you is that attorney advertising is $100 million. The pharmaceutical industry spends $30 billion a year annually for marketing to get people to buy their products. If they're that concerned about the safety of this product, then perhaps they could spend some money with market research or education on the topics. The reality is this is a bill being introduced by big pharmaceutical companies to prevent injured Kansans from getting help when they need it. That's all it boils down to. There's no other legitimate reason other than that. With respect to the chamber being here and testifying, I appreciate Mr. Stafford being there. The purpose of the Kansas Chamber, from my understanding, is to be an advocate for pro-business public policies that allows all Kansas businesses to succeed. There's an assault on free speech in this country right now, and it's concerning to me, and it should be concerning to all of you. Today, it's attorney advertising. I don't know what tomorrow is going to be, but what I don't want is an infringement on any of my rights outlined in the Bill of Rights. With that, I will stand for questions at the appropriate time. I appreciate all your time today.
Thank you, Mr. Clausen, and welcome back to the Capitol. You're not here in person, but you've paged a couple times, and you're with us here in the committee meeting room. So that's pretty exciting, 3 times to be a page.
Thank you, ma'am.
You bet. So then we will circle back to Mr. Jason Roth to determine if he has joined us by WebEx. Do we have any information that he has? Or Mr. Roth, are you hearing us and can identify yourself? I'm not hearing anything, and from our IT staff here, we are not seeing that Mr. Roth is joining us on WebEx either. We'll go ahead and continue with the hearing and ask one last time before we close the hearing today. With that, I will ask, are there any other opponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, I'll then direct the committee's attention to opponent written testimony in your committee folder and online. Allison Mazzei from the Kansas Association of Broadcasters, and Jonathan Vogelli, law offices of Slape and Howard. So with that committee then, we will open it up for questions of our opponent conferees. Do we have any questions? Yes, Senator Thompson.
Thank you, Madam Chair. With regard to the Kansas Consumer Protection Act 50-623, it says this act shall be construed liberally to promote the following policies. And in A, it says to simply clarify and modernize the law governing consumer transactions. I'd be curious to the reaction to any of the opponent conferees is how this doesn't clarify, some of the legal practices that we're seeing. I've seen some of these advertisements on television, and they flash all these things on the screen. The font is so small, you need a magnifying glass with a 50-inch screen to be able to read this stuff, and it's on there for 1 second. So I would just curious how this doesn't go a little bit further to protect some of these people from some of these ads.
Thank you. And would Mr. Molina and Mr. Clausen like to respond?
I don't have the KCPA in front of me. I'd be more than happy to look it up and respond. I don't have an answer for you, Senator Thompson, at this time. Mr. Molina.
And, please identify yourself. Who was just speaking?
I'm sorry, Chairwoman. That was Cody Clausen. I'll defer to Mr. Molina.
All right, thank you. Please introduce yourself. And
Joe Molina with the Kansas Bar Association. It's not that it doesn't clarify it, it's that it's not its place. The place for this to happen is with the Kansas Supreme Court. We have a process. If you want to go ahead and review a certain rule of professional conduct, there is a process, a comment period that we can do. And that's where this authority should stay. The Kansas Constitution says that they have this authority. Article 3, Section 1, like I mentioned earlier. And so I believe that answers your question.
To some degree, I need to look at the Constitution very quickly. How many cases like this Madam Chair, I'm sorry, where disciplinary actions are being considered by the Supreme Court? How many of those cases?
Joe Molina with the Kansas Bar Association again. Actually, I'm not sure. I sent a message over to the Disciplinary Administrator's Office, but I have not heard back yet. When I do, I'll make sure I let the chair know of the information.
Thank you. Thank you, Madam Chair.
thank you. Senator Wilborn.
Thank you, Madam Chairman. And Mr. Molina, since you're here, I'll just let you stand there for a moment or two.
Yes, sir.
Are you telling me that the Supreme Court has jurisdiction over advertising outside of the legal profession? Because I see on television, a lot of these aren't lawyers. It's a separate ad agency using the word recall when there has been no recall. Who's going to regulate that part of it?
I understand. Joseph Molina with the Kansas Bar Association. I understand that part of it. The bill actually defines what a person is. And they say very specifically that a person is a lawyer or a law firm. And so it seems to very directly impact the legal community because the bill itself defines it that way. And so I think the question that we're talking about might be a very different circumstance. But when we look at Senate Bill 150, you look at the definition of what a person is. It includes a lawyer or a law firm. In that case, the Kansas Supreme Court, under their constitutional authority, should be able to regulate that situation.
Thank you, Madam Chairman. Again, Mr. Molina, and I understand your point, very good point. However, many of these misleading ads are by feeder ad agencies feeding information, and we need to get control of that. Do you have any suggestions along those lines?
Joe Molina with the Kansas Bar Association again. I would have to look at that a little bit more. I'm not saying, and I don't want it to be taken that this body or the Kansas legislature cannot regulate some form of speech. We know that the Supreme Court has said that in certain circumstances you can't, but in most of those circumstances, that is a very, very high bar. You must survive strict scrutiny if it is content-based First Amendment prohibitions, or an intermediary type of scrutiny if it's commercial type speech. So this body can in certain circumstances, but you're going to have to pass a pretty high bar when you want to go ahead and restrict or limit First Amendment rights. And when we talk about the legal advertising portion of Senate Bill 150, we would rather defer to the Supreme Court and their authority in that matter.
And I thank you for your response.
Thank you, sir.
Thank you. Do we have other questions from the committee? Yes, Senator Gossage.
Thank you, Madam Chair. Mr. Molina, I was looking in the definition in the bill of a person, and it says, you're right, means an attorney, a law firm, but goes on to say an individual or an entity that advertises legal services or identifies potential clients for attorneys or law firms, right?
Yes, ma'am.
So I've definitely seen these being in the health realm, and I've written health insurance now for 18 years for people. I've been deeply concerned about people who've called me and said, oh, I quit taking that because I saw this ad at 2 o'clock in the morning that told me it causes this or this. And you're like, don't stop doing that. So I agree that something should be done, but what concerns me is if you're saying this should fall under the jurisdiction of the Kansas Supreme Court, and I don't disagree with that, but we don't seem to know of any cases in which they have found someone to be guilty of doing this. Is that because they're not here in Kansas or domiciled here in Kansas, but yet they're advertising here?
Joe Molina with the Kansas Bar Association again. There's a couple questions there, so let me try and take them one by one. I am not aware of any cases in Kansas, and I can't tell you why they're not here. And again, I'll reach out to Stan Hazard's office, and I'll definitely talk to some other colleagues to see if there are any other types of reasons why we don't see these things coming up. And so I'll make sure I get back to you on that. Your other part about when people, or the anecdotes of people saying that they stopped taking medication, and you have one personal one where someone called you, it is a valid point. My response to that is, lawyers aren't doctors. And I am a little hesitant to have a lawyer give out what would be medical advice in almost any circumstance. And so we might want to look a little closer at that, I would say. It's just something off the cuff. I'd have to run it past more of my colleagues to make sure. But that is just one of the things that popped to mind when I saw some of that language.
And then, if I may, Madam Chair, another concern that I have is this appears to be, as my colleague, Senator Wilborn pointed out, most of the time they're not representing themselves as a law firm, but just saying, you know, we care and call this number, et cetera. And I agree. I think there definitely should be something done. I think everybody in this room is concerned. It's the what should be done. And when I see the list of things that were given, just identify yourself. You know, if this is a law firm, say that. I know when I write Medicare for Medicare beneficiaries, I have to clearly state I am not employed by Medicare. Can't put Medicare anywhere on anything. That seems to be something that should be common sense. So under what ruling or under what jurisdiction do you think this should fall?
Joe Molina with the Kansas Bar Association. I believe that is Rule of Professional Conduct 7.3. And under that rule, you must state very explicitly, if it's a printed thing, on the outside on the envelope, that this is legal advertising. And so the Supreme Court actually thought about this, that specific scenario, and requiring that when it is an ad, they say that it is an ad. And if you violate that, then you could have repercussion of discipline from Stan Hazard's office.
And is this print only?
I'd have to reread the rule. I read the print only, but I'm not sure if they updated it to include any other electronic situations.
Thank you, and thank you, Madam Chair.
Senator Thompson.
Thank you, Madam Chair. You could probably answer this question, and I'll ask it of Mr. Molina. I was looking at Article 3, and I'm just curious. I'm trying to find the section that covers the disciplinary action, or could you point it out to me so I could read it?
Joe Molina with the Kansas Bar Association. It's Article 3, Section 1. Okay. I believe it's the last sentence.
Okay, I see it. Thank you, Mr. Molina. Thank you, Madam Chair.
Thank you. And committee, before we entertain any other questions, I do have information that Jason Roth is available on WebEx. So we will invite Jason Roth to introduce himself, and welcome to committee.
Thank you, Madam Chair. Members of the committee, my name is Jason Roth. I'm an attorney in Overland Park, Kansas. I appear today on behalf of the Kansas Trial to testify in opposition to Senate Bill 150. Kansas has rules and a disciplinary process for regulating advertising attorneys. Senate Bill 150 is and unnecessary. It's potentially unconstitutional based on a ruling of a similar case or similar law enacted in West Virginia. KTLA, I respectfully request the committee oppose Senate Bill 150. KTLA supports consumer protection laws that deter deceptive advertising. Prohibitions on deception and advertising should not be limited to one profession or industry. Senate Bill 150 is a flawed attempt to create special laws targeting advertising by the legal profession. First, Kansas has a long established rules that govern attorney conduct, including communications and advertising. The rules of professional conduct are enforced within the judicial branch through the Office of the Disciplinary Administrator. The applicable rules are 7.1, 7.2, and 7.3. Rule 7.1 defines and prohibits false and misleading communications. Rule 7.2 provides specific guidance about advertising content. And 7.3C requires that advertising material be identified as such. The rules of professional conduct protect consumers by establishing clear standards and meaningful penalties. An attorney that violates the rules faces a disciplinary complaint, investigation, review, and sanctions ranging from informal admonishment to discipline by the Supreme Court, which could include probation, suspension, or disbarment. The Federal Trade Commission also may review advertising for compliance with the FTC Act, including unfair and deceptive advertising by attorneys and deceptive advertising that has an effect on drug or device sales. Letters from the Federal Trade Commission to attorneys regarding possible violations of the Act have directed that ads include clear and prominent audio and visual disclosures stating people should not stop taking medications without consulting a doctor. In addition to overlapping with current laws, Senate Bill 150 has an even bigger problem: constitutionality. Attorneys have the right to advertise, and such advertising is protected commercial speech. Senate Bill 150 attempts to control the content and advertising and is a governmental intrusion on the First Amendment. A 2002 federal court decision supports the conclusion that Senate Bill 150 could be found unconstitutional. The federal district court in the Fourth Circuit granted an injunction preventing enforcement of a nearly identical West Virginia law, finding that it likely violated the First Amendment. The court in West Virginia found that the law was content-based and the burden was on the state to show its restrictions were narrowly tailored to serve a compelling state interest. The court determined that under either strict scrutiny or intermediate scrutiny, the West Virginia law failed. The Fourth Circuit also cited the U.S. Supreme Court in holding that the state cannot limit speech in order to control the public debate, and it is the speaker and the audience that determine the value of the information, not the government. The Fourth Circuit's holding in REC must serve as a cautionary tale against Senate Bill 150 and its likely violation of the First Amendment, which protects attorney advertising. Senate Bill 150 is unnecessary because the rules of professional conduct and their enforcement within the judicial branch is appropriate, effective, and protects consumers. On behalf of the members of KTLA, I respectfully request your opposition to Senate Bill 150.
Thank you. With that committee, then, we will turn to any further questions for our opponent conferees. I have a couple of questions that were brought up by the good, lively discussion today. I've noted in the bill on page 2 at line 12, when we're talking about what's being regulated here, or what the bill proposes to regulate, is legal advertisement, which would be a service then. So it's not, in my mind, really aimed at a particular profession, but a service or a product. And as it's been pointed out as well, a person is defined in the bill at line 16 to not include just attorneys or law firms, but any individual or entity who advertises legal services. And those might not be attorneys or law firms. And we've heard a lot about the disciplinary rules of the Kansas Supreme Court, particularly Rule 7.1, 2, and 3. And my question for the conferees is, the disciplinary rules, they only apply to attorneys, right? And not others who may engage in advertising or putting out there, producing, disseminating legal advertisements. That's my understanding of what the disciplinary rules from the Kansas Supreme Court provide. If Mr. Molina's in the room from the Kansas Bar Association, if you have a response or can speak to that, and I think, go ahead. Thank you, Mr. Molina.
Joe Molina with the Kansas Bar Association. I believe you're correct. The rules of professional conduct for lawyers are only specific to lawyers here in Kansas.
Right, thank you. And I understand certainly the First Amendment concerns, and I would share some of those concerns as well. But I'm looking specifically at, on page 2 of the bill at line 27, where it's talking about defining what a violation of this section is, and that it would be an unlawful and deceptive trade practice as provided in Kansas statute at 50-626. That's the Consumer Protection Act. It's a section of the Consumer Protection Act. And I'm looking at section 50-626, and it talks about, at subsection B, that deceptive acts and practices include, subsection 1 is representations, and representations then are speech, and further down in section 50-626 at subsection B11A, it talks about specific language that must be included when sending or delivering a solicitation for goods and services, and it dictates the specific language. This is a solicitation for the purchase of goods or services and not a bill, invoice or statement or account due. You are under no obligation to make any payments unless you accept this offer. And in the notice requirements of the statute continues. So Kansas has regulated commercial speech, at least here in section 50-626. And my question is, if you know, has this been determined to be unconstitutional?
Joe Molina with the Kansas Bar Association again. The question, your question was whether that portion of the Kansas Consumer Protection Act was deemed unconstitutional.
Right. If you know, it's been, it originally was enacted in 1973 and was last amended in 2010. So I'm wondering.
Joe Molina with the Kansas Bar Association again. I am not sure. I haven't seen any litigation on that point. From our standpoint is that section of the Consumer Protection Act does not apply to lawyers.
Right, I understand, but what the bill purports to do is to make kind of a regulating speech in the same way as 50-626 already does. So I would ask then, is this something new that Senate Bill 150 is trying to do, or is it, and maybe that's for a proponent conferee, if Mr. Stafford or Mr. Silverman can respond. It looks like Kansas already has in place regulating speech like Senate Bill 150 purports to do. Is that Correct, and go ahead, Mr. Molina, if you have an answer to.
Joe Molina with the Kansas Bar Association. The difference here for us, right, is that this is the bill has a definition that includes lawyers and law firms. That is the difference. You've already, as you pointed out in the Kansas Consumer Protection Act, we've already laid the groundwork, per se, on certain other types of advertising. But this one specifically talks about and pinpoints the legal community in its definition. And that's where most of, if not all of our opposition comes from.
Sure, to just direct it at the legal community, and I understand. And let me ask, I understand, the disciplinary rules and how that is used in the legal community. And what, though, are there anything, refresh my recollection, are there anything, any remedies provided in the disciplinary rules for consumers who are harmed by the action that the attorney is being disciplined for? Is there a remuneration? Is there expenses paid? Or is there any remedy for the consumer hurt by the action that the attorney is being disciplined for?
Joe Molina with the Kansas Bar Association. There is a fund where some harmed consumers can recover some fees. When you talk about that fund, in my experience, it is people who have absconded or embezzled from a trust fund. And then you can apply to this fund. For the life of me, I cannot remember the name of that. And I can find it for you, and I'll get it for you.
Appreciate that. There's a fund. Is there a fund likewise if a consumer suffers some personal injury because of the action that the attorney is being disciplined for?
Joe Molina with the Kansas Bar Association. I'm not sure. I'd have to check in and look into that for you. I will.
Do we know, is Kansas Legislative Research Department able to look at that as well, possibly while we're still in the hearing? I think that would be important to know for the committee and for the public listening, whether there is a fund available if you're a consumer who has suffered some personal injury, alleged personal injury because of action that an attorney is being disciplined for. So
I'm not sure. I'll have to look into that.
Sure, appreciate that. And I don't mean to take up a lot of the committee time, but we have a question from Senator Wilborn.
Thank you, Madam Chair. Mr. Molina, I have a question that's kind of a hypothetical. Let's say this law firm is doing everything just right, but they buy this data or get this data from this advertising agency that is not. Do you see any vicarious or agency liability connection between the two?
Joe Molina with the Kansas Bar Association. That's a very interesting question. Honestly, I'd have to look into that. That's a good question, though. I'm not sure.
Thank you.
Yes, Senator Gossage.
Thank you, Madam Chair. As I'm looking at your testimony, Mr. Molina, and thank you so much for being here, it says the Kansas Rule of Professional Conduct 7.1, and it's been mentioned several times, but it clearly states a lawyer shall not make a false or misleading communication about the lawyer or the lawyer's services. I don't feel that what we're discussing here is really related to the attorney's services. It's related to false information that is given or misleading information and a lack of disclosure as from whom this ad is or the beginning of this ad, or who is sponsoring this ad. I don't see that falls under 7.1. Can you help me with that?
Joe Molina with the Kansas Bar Association again. We believe it does. It's a legal advertisement. The bill defines it as such. It defines the people who are responsible under Senate Bill 50 as lawyers or law firms. So I believe there is a tie-in. And from our point of view, when you talk about legal advertisement and about misleading and deceptive ads from lawyers, in the first place we look as lawyers is 7.1. And that's where we go, and that's where we focus on to make sure that what we're doing is within the bounds of the rules of professional conduct. So we do see a tie-in.
So a follow-up, if I may, Madam Chair. So if this is not, I'm just thinking, I'm not an attorney, but if I was an attorney, I could see saying, well, this is not any misleading communication about my services that I offer. We're just saying, hey, if you were affected by this, you may want to call this number. Nothing to do with my particular services.
Then we would say that take out all the references to the law, the lawyer and the law firm. If that is, because right now, you already have some type of laws under the Kansas Consumer Protection Act that deals with these types of things. You're adding lawyers and law firms to that group in the Kansas Consumer Protection Act of people that need to be regulated further. And we're saying that the proper people to regulate that would be the Supreme Court and not the Attorney General's office. And that's all we're saying. And I understand where you're coming from and that it may not seem, but the bill itself dictates and states that it does affect lawyers and law firms. And so that's where we're coming from.
Thank you. Thank you, Madam Chair.
Madam Chairwoman,
Who's speaking, please?
Cody Clausen.
Sure, did you have a response to the question?
I did, if that's okay.
Sure.
There's a couple questions there. I didn't know when to unmute, so thank you for giving me the opportunity. There's a couple things I want to outline. The whole reason that I'm here is because the bill is directed towards lawyers. Perhaps if the committee is so inclined and if we're so concerned about it, we should amend the bill to apply to non-lawyers. I think that's the whole purpose of the KCPA is to have civil penalties up to $10,000 per deceptive practice. That's the purpose of the KCPA. With respect to Senator Wilborn's question, yours was with respect to the data, I believe, something to that effect. Attorneys in the state of Kansas, that is another source that Stan Haslett's office does provide guidance over. Any data that attorneys have or don't have is all subject to the discipline of Stan Haslett's office.
Thank you. I have a follow-up question for Mr. Roth. My question is, we've heard that the Kansas Supreme Court has its own procedure and process and rules in place that govern attorneys. And I believe the Board of Healing Arts does likewise for physicians. Is it the Kansas Trial Lawyers Association position that likewise, I guess, physicians, because they're governed by the Board of Healing Arts, that they can't otherwise be regulated?
Thank you. I don't, the Kansas trial lawyers are against any sort of deceptive acts or practices, whether it's the Kansas board, whether it's a healthcare provider, a pharmaceutical company, an insurance agent. It doesn't. The KTLA is against all deceptive acts and practices. Your question about the Kansas Board of Healing Arts, I think you may have cut out. I didn't understand it.
Sure. My question would be, for those who are listening online, and they might be thinking, well, physicians are governed by the Board of Healing Arts. So does that mean then that Kansas can't otherwise regulate by law physicians? And kind of equating this to the bill in front of us that, well, if the Kansas Supreme Court already regulates attorneys, does that mean then that the Kansas legislature can't regulate attorneys at all? I'm just wondering if there's a parallel there, if you will. It seems inconsistent that if we can regulate physicians, though there's a Board of Healing Arts, why is it the position that we can't also regulate attorneys, though we have the disciplinary system of the Kansas Supreme Court?
Right. The concern that I would have would be the constitutionality of limiting, let's say, doctors advertising their services on TV. They would be held to standards of being accurate in their advertising.
Thank you. And isn't that what SB 150 intends to do? For any person advertising legal advertisements?
Well, I think it's aimed directly at lawyers. And the lawyers already have oversight, and there's constitutional concerns with the bill.
Thank you. Committee, do we have other questions? Yes, Senator Thompson.
Thank you, Madam Chair. Either of the opponents would be fine to answer this. I'm having trouble seeing the problem. All this is doing is setting guidelines for deceptive practices, and as long as you could advertise and stay within those guidelines, I am having difficulty understanding what the objection is. I think, you know, this falls within the Consumer Protection Act of 623, I think, says you can liberally apply the protections, and this just adds some clarification. I'm very curious to response on that.
Do we have a response from an opponent conferee? I see Mr. Molina approaching.
Joe Molina with the Kansas Bar Association. I should have sat closer. The difference is the constitutional granting under Article 3, Section 1. That's the underpinning, right? That says that the Supreme Court gets to regulate lawyers. That is probably the difference between how we regulate lawyers versus how we regulate doctors under the Board of Healing Arts. You won't find the Board of Healing Arts in the Constitution. You find the protection, I shouldn't say protection, the power granted and authority to the Supreme Court in the Constitution. You don't see that. The Board of Healing Arts is a state agency. You guys can regulate them as you see fit, because that is part of your duty. The Supreme Court's duty and part of their authority is regulating conduct of lawyers. And that is a difference. And because the Consumer Protection Act is construed liberally, for those acts that are not lawyer-focused, they have every right to go after them. Being a former Assistant Attorney General that actually practiced in the Consumer Protection Division, that's what we did. We went after those people for significant fees. But when you're talking about what Senate Bill 150 does is you're focusing on lawyers who are officers of the court, and they are regulated by the Supreme Court. And that is the difference. That is the point, I believe, that we should take away from this, and that is the basis for our objection to Senate Bill 150.
Thank you. Thank you, Madam Chair.
Thank you. Mr. Molina, that brings up one question for me. What would the Kansas Bar Association, tell the people of Kansas if they are dissatisfied with how the Kansas Supreme Court is regulating attorneys?
There is a process to go ahead and have those rules, I don't want to say opened up, because I don't think that's the formal term, but reviewed, and there's a comment period. We've done that with a number of bills in the past. I believe we did one to Rule 710, allowing certain nonprofits to allow their attorneys to work pro se for certain individuals. And that was just one of those things that was a public grassroots effort that grew up. So there are ways for these things to actually be reviewed by the Supreme Court.
Is there a specific process in place if the public wanted to have a review of Rule 7.1, 2, or 3, or would it have to be the Supreme Court would have to take the initiative and put it out there for comment?
Joe Molina with the Kansas Bar. I believe there is a process, but I don't know it exactly, so I'm going to have to get you that information.
And it's different than the legislative process, right? It wouldn't be that a constituent could bring a bill to the legislature for the legislature to debate and consider. It would be something controlled by the Kansas Supreme Court, if I'm understanding correctly.
Joe Molina with the Kansas Bar Association. I believe so, but again, I can't say for certain.
All right, thank you. Any other questions, committee? I want to then thank all of the conferees who appeared in person and on WebEx. Appreciate you doing that, especially on this cold winter day, and appreciate your thoughtful testimony. Appreciate the questions and the lively debate today as we look at the proposed bill and just want to remind the committee that we're thankful for all the testimony and the conferees who appear, both proponents, neutral, and opponents of any bill. And we thank you for appearing in front of the committee today as part of the Kansas Legislature. And with that, then, we've had some good work today, and I would thank the committee and the public for listening and the conferees. And we are then closing the hearing on Senate Bill 150. And with that, we are adjourned. Thank you.